authority the issue relating to subjecting civilians to martial law, which my learned friend here adequately canvassed. But the authority, and he cited a number of authorities. He cited the ones of Uganda Law Society, cited Laba, and cited Kabazikuruka and a couple of others. But the point I wanted to emphasize, there are two authorities that have come subsequent to the decision of Kabazikuruka. The one of Laba, which is 2022, and it was very, very clear. And on that one, there was an appeal. The one of Laba. Yes, the Attorney General appealed, preferred an appeal against the decision in the Kabazikuruka matter. But the one of Laba, there is no legal. There is no any order of state, and no any other far order in that regard. My learned friend alluded to the fact that the other side may raise a contention that there was an order of stay in the Kabazikuruka case. That has also been subsequently handled by the Constitutional Court, which took a decision in that case. They have decided, one, in the case of Laba, but more sufficiently in the case of Semuju Abdul versus the Attorney General, Constitutional Petition number 4 of 2018, the most recent one. It is, to be exact, it is the 3rd February 2023. It is as fresh as these judges before you. This decision, the lead judge, may his soul, Justice Kakuru, may his soul rest in eternal peace, had the occasion to reproduce verbatim the decision in the Kabazikuruka case. He summed them up, and he said, the constitutionality, no, I have carefully listened and considered the submissions of both counsel on the constitutionality of sections 2, 119 and 197 of the UPDF Act. I have also carefully perused the affidavits and so on and so forth. The constitutionality of the issues raised above were substantially raised and settled in the recent constitutional decision of Honorable Michael Kabazikuruka versus the Attorney General. That is Constitutional Petition number 45 of 2016. Then he said, I will reproduce the declarations in extension for clarity. He highlighted them. I will not take your time, but they are very few. Yes? Yeah, just number 5. No. The General Court Martial established under section is, no, number 2, the General Court Martial's jurisdiction is only limited to trying service offences under the UPDF Act. Then, he said, 3, military law under the UPDF Act must be construed to exclude laws that are the preserve of the civil courts of judicature. I will come to that later when I'm raising another issue. But more specifically, number 4, persons subject to military law. 5. Sections 119, 1H, subsection 1 of section 179 of the UPDF Act are unconstitutional, as they are inconsistent with Article 28 of the Constitution. That is a finding which is well captured in the decision of Kabazikuruka and reproduced in a number of those decisions. And they had the occasion to make this finding after listening to the submissions of the state that in the Kabazikuruka matter there is an appeal, there is an order of state. This is what the Constitutional Court said after listening to the submissions, which are likely to come from the other side when they are replying. This is the response and the finding of the Constitutional Court. The above authority is good law, and I am bound to follow it. We are well aware that the above cited decision is currently pending appeal at Supreme Court. Until the Supreme Court decides otherwise, the authority is still good law. The fact that gave rise to this petition are almost on all fours with those in Honorable Kabazikuruka's case. Applying the above authority, I find that the petition is on all fours. The petition is therefore allowed on that account alone. The same declarations and orders in the Ageesigika petition apply to this petition. This is as of recent as 2023. So, this court, I'm afraid to say, its hands are now tied. It has no choice but to go by the declarations in the Ageesigika decision and reinforced in the decision of Semuju and Yagaba and others which have come subsequent to the one of the submission I will make here. Again, in emphasizing the point Fred Mpanga here has raised of Article 3, any attempt by this General Court Martial to proceed with the prosecution in total disregard of this finding of the Constitutional Court, with all due respect to the General Court Martial, to be treason. It will amount to treason for this General Court Martial to proceed with the prosecution, with the hearing of the matter, in total disregard of this, because the Constitution Article 3 is very, very clear on the observance of the constitutional order, respect to the given constitutional order and interpretations given. So I urge you, Mr. Chairman, members of the panel, not to commit issue and proceeding with this matter. Now, Mr. Chairman, with your permission, I beg to move and frame to 3 issues. The first issue, in addition to the ones, the first one is about the propriety of the proceedings, the charge sheet canvassing Mr. Chairman, whether the trial premised on arrest and rendition of accused persons from Kenya in total disregard of the extradition law and other international laws, and on the basis of a memorandum of understanding which is not within the framework of the extradition laws, amounts to a violation of Article 28 of the Constitution. Mr. Chairman, in your finding this morning, you indicated that there is an MOU between the government of Uganda and Kenya to exchange people presumed to have committed offenses, which obviously is not premised on international law or the existing extradition acts or laws of both countries. So that is a matter which requires constitutional interpretation. Can there exist an extradition treaty outside? No, not a treaty, an MOU, yet the law provides for an extradition treaty. And isn't that a violation of Article 28 of the Constitution, which guarantees the right to fair hearing and other relevant provisions? So I don't need to labor so much because we argued out that point earlier on. I would like to adopt the submissions we made earlier on about rendition in violation of the extradition laws. So I would like that issue matter also to be referred to the Constitutional Court. The other issue, Mr. Chairman,